Hello, law students. I'm Jonathan Lipson, and this is The Real Deal on Contracts. And today we're going to talk about buyer's remedies, in particular, the kinds of damages that they can get if a seller breaches, and the particular problem of foreseeability that often arises when a buyer is trying to recover certain types of damages. There are really three things we want to cover. First, just what is the range of things that buyers can get in terms of damages. Second, we'll focus in particular on one especially important category known as consequential damages. And third, I'll try to give you some practical examples of what we mean by consequentials. The overarching concept in buyer's remedies is similar to the concept in seller's remedies. When we're talking about buyer's remedies, we say that the buyer is entitled to their expectation interest. We want to put them in the position they'd expected to be in had the seller not breached. UCC Section 2711 has a sort of menu approach, not unlike the menu approach you see in 2703. One of the things to notice at the outset is you want to keep straight in your head the basis of the seller's breach. And the distinction that we make is between a seller's non-delivery or repudiation on the one hand versus a buyer's rightful rejection or revocation of acceptance on the other. That's a bit of jargon. We'll go into it in greater detail a little bit later, but non-delivery means what it sounds like. The seller just didn't deliver. Revocation or rejection by the buyer means the seller did deliver, but what they delivered didn't work. There was a problem with it. We talked about that in Units 8 and 8.1. If either of those kinds of things happen, the buyer can exit. They can cancel the contract. They can walk away. In addition, they can recover so much of the purchase price as has been paid. It's sometimes called restitution. And these are all set out in 2711. 2711 refers you to two different types of difference measures that the buyer might seek to recover. If the buyer has gone out and found a substitute, they have mitigated, they will have done what we call cover. And if they had to pay more when they covered, then they get the difference between the cover price and the contract price. It's fairly straightforward. Cover contract difference. If they didn't mitigate for whatever reason, for example, they couldn't, they can get the contract market difference. But in that case, only if there was non-delivery by the seller. That's where that distinction between the types of the basis of the breach matters. So you get the contract market difference if the seller didn't deliver, or you can if you want. Get the contract market difference if the seller didn't deliver. You can get the cover market difference in any of those cases, any kind of seller's breach. Buyer gets incidental damages. Pretty much look here like they did with seller's damages. They're post-breach remediation costs reasonably incurred by the buyer or the non-breacher. Last and probably most tricky, consequential damages. Under 2715.2, the buyer is entitled to recover their consequentials. So this takes us to the second sort of thing to think about. What are consequential damages? Halley versus Baxendale is one of the two main cases you read for this unit, and it's certainly one of the most famous chestnuts of contract literature, such as it is. And it sets forth the test for consequential damages under the common law. Basically, it says that the buyer is entitled to damages which the other party, the seller, damages such as may fairly and reasonably be considered either arising naturally, that is to say in the usual course of things from the breach of the contract, or the damages that were in the contemplation of both parties and that would flow as a probable result from the breach of the contract. So sort of two different tests or kinds of consequential damages, two different ways, I guess, the buyer could assert consequential damages. Either they just flow naturally, and sort of everybody should know, would have known that the kind of claim the buyer is asserting would arise as a consequence, or instead, the seller had specific knowledge because the damage was in the contemplation of both parties. That's a common law test. It's kind of reiterated in Restatement Section 351. The UCC has its own version of consequential damages in 2715-2. It's loss resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know and which could not reasonably be prevented by cover or otherwise. Okay. So it's worth thinking about, well, how are those two different, common law and UCC? Third point, what does any of this really mean? Usually what buyers are really trying to get when they talk about consequential damages is profit that they lost due to the seller's breach. There's other forms of consequential damages, so don't assume that's the only thing. We'll talk about others later, but that's usually the main one. And so what that means is that we've got a buyer that is in business itself. If the seller's breach caused the buyer to lose profits that they expected to make, maybe they get to recover them. And so, you see in Hadley versus Baxendale, the defendant, Pickford, is supposed to be shipping a shaft and they don't deliver it when they're supposed to, and, the Hadleys don't make the profit they expected to make. So you think that might be consequential damages, but when you read the test that was articulated in that case, maybe you'll start to see why they didn't. But it's still worth asking yourself, well, why didn't the defendant know or have reason to know that the plaintiff, the buyer, would lose profit when the shaft wasn't delivered? What kind of knowledge, in other words, is required to enable the buyer to recover lost profits? Second, a sort of special example of that problem, that knowledge problem, involves a situation where the buyer is a new business, so they don't have a record of profits. The Chung case talks about that explicitly. And third, all right, well, let's assume for the moment that you got a buyer like, the buyer in Hadley versus Baxendale, and they can't recover lost profits. What do they get then? Are they just out of luck? Well, the answer is they're not entirely out of luck. They get another kind of remedy, another kind of damage relief. Begins with the letter R. It's a hint, which we'll talk about in Unit 7. In the meantime, that is the real deal on contracts.